Hey everyone, Rob Ryder. It's August 11th, 2013. That'd be a Sunday. This is going to take a while, so you may want to stop now, go grab a beverage, whatever it takes to make you relax, right? Go do a one-hitter, because a lot of this is conceptual. In other words, I really can't tell you how to use it yet, or we got to take some swags at things, but it's more to do with what it looks like, how things are set up. So this is goes on with what we were talking about with the ordinary last week, and the county ordinary and the local ordinary, and what powers an ordinary has, and just who the hell is the ordinary. Well, let's look at a county level. In this county, they have a county executive. And if you can see this little dotted line, the county executive has some kind of control over all these other divisions. Circuit court, district court, clerk, probate. And none of them go through each other. They're directly from him to them. Okay? And then there's a board of commissioners. Now, but he kept the executive power. So the legislative power went to the board of commissioners. The executive power is in the office of the executive, and he's delegated the judicial power to the different courts. However, the way the system is set up, they're all the powers of an ordinary, and they've been delegated to others, but all of them originated from the county executive's office. So the county executive has the power to legislate, judge, and execute the law. And that's the administration part. All right, so county executive could be called a county administrator. It just really depends on what his job function is. It could be you just have a board of governors or commissioners or whatever it is, and there's a president of the board. It could be him. Because there's many ways that counties are set up, as we'll look at in just a minute. But let's just look at a few definitions real quick and we'll get started. So an ordinary is an officer of a church or civic authority who, by reason of office, has ordinary power to execute laws. We want the guy that has the executive power. Not to judge the law or judge by the law, not to legislate or make the law, the one who has the power to execute the law. He's the ordinary. An ordinary in ecclesiastic language denotes any person possessing or exercising an ordinary jurisdiction, i.e. jurisdiction connected permanently or at least in a stable way with an office. Okay, so I'm just thinking that it's the county executive office that has the ordinary power. When we get deeper in these definitions, you'll see, okay, this is how they split it up and give some to these people and some to these people, and some people have delegated power, some people have original ordinary jurisdiction, and then it's just for a small jurisdiction, but then they can have additional added from somebody who has a higher level of ordinary power over a larger territory. So the ordinary is local to whatever the territory size we're talking about. And so let's see what we got here. When independence came, the framers of the Constitution did not provide for local governments. Rather, they left the matter to the states. Subsequently, early state constitutions generally conceptualized county government as an arm of the state. Right? So we got to quit thinking of it as a county government. It's a state government. It's just the local administrative branch of the state government. Okay? A chief administrative officer is responsible for administrative management of private, public, or government offices. The CAO, the chief administrative officer, is one of the highest ranking members of an organization, managing daily operations usually reporting to the chief executive officer. All right? So the chief administrative officer, right, is the day-to-day administration within a jurisdiction. Who answers to the chief executive officer? Right? So who is the chief executive officer of the state? Governor? Is it Secretary of State? I don't know. But it's the administration. We're talking the administration, right? So when we talk about these being administrative courts, that means they're courts of the executive office. And some company CEO is also the president. It is very similar to the chief operating officer and is not the same as a CEO, which is a more senior title. So the chief executive is above the chief administrative. But within every county is a chief administrative officer who answers to the chief executive officer of the state, because it's a state government, and he's responsible for the state government within a defined territory known as a county. In a municipal context, the title usually is used as an alternative for city manager, county administrator, or county executive, particularly in cases where the position does not include powers such as the authority to appoint or dismiss department heads. So this dude may not be able to fire any of these people. They're all department heads. You got a department head over the sheriff, treasurer, right? It's not that he can fire them. It's just he answers to the executive, chief executive, who can fire them. It does not include the power to appoint or dismiss department heads. Okay. In the United Kingdom, CAOs of public companies must be chartered secretaries, right? So what's a public company in the United Kingdom? Well, one of their jurisdictions is going to be a public company, and they're a chartered secretary. So they're going to be called secretaries. Now this is for this guy here, Bay City. This is off of his website. The county executive as chief administrator. So what is he? It's the chief administrator. Who are we looking for? The chief administrator. Right? What does administration mean? Executive, right? It's the executive arm of the state government at county level. And he answers to the chief executive of the state, who is bound to enforce the laws of the Constitution of the state. And a constitution is an ecclesiastic ordinance. A civil ordinance is called a law. A constitution is an ecclesiastic ordinance. And so an ecclesiastic ordinance is called a constitution. And so somebody is the chief executive officer of that ecclesiastic constitution, and whoever that is for, I'm going to say it's at state level, right, is the, I don't know, you're going to call him the bishop of the state? Of that particular ecclesiastic franchise. Franchise probably isn't the right word. Ecclesiastic society. That's what it is. It's an ecclesiastic society that has an ecclesiastic ordinance called a constitution. The county executive, as chief administrator, has influence over all departments except those headed by other elected officials. In that manner, the county executive appoints and supervises all department heads. It is the duty of the county executive to coordinate all county activities and unify the management of county affairs, enforce all orders, rules, and ordinances passed by the Board of Commissioners and all laws enacted by the state. In addition, the county executive must submit to the Board of Commissioners a recommended budget each year. The county executive, like other elected officials, is independent of the Board of Commissioners, yada yada, yada yada, so he's independent. The office of, so this is also on there, he's got an ombudsman's office. The office of the ombudsman was established to receive, investigate, and to seek to resolve all justified citizens' complaints against Bay County government. Well, the Bay County government is really just an administrative arm of the state government. The ombudsman will provide information and referrals and recommended alternative actions when citizen complaints do not fall within the jurisdiction of service rendered by the county executive. That's who we're supposed to be taking our complaint to, whether it's called the ombudsman, county executive, county administrator, whoever the chief administrator, who's ever the chief of administration. So in some counties you could have a board and it has a president, and that, but if you look at what his title is and what his duties are, if he's the chief administrator of the county, he's the guy we're talking about. Now, one of his jobs is to, where did I say that? Right. Enforce all orders, rules, and ordinances passed by the State Board of Commissioners and all laws enacted by the state. Okay, well, the state enacted this thing called the Penal Code. And a year and a half ago, I wrote maybe 7 different complaints up using the Penal Code as the basis. I've told the story numerous times, and at the end of the day, I had a chief judge of a district court say, well, it's not that you're not correct. She just wasn't inclined to issue any warrants. And I said, so you're going to allow a usurper of an office using color law to steal my property? Because I was in jail, unlawfully imprisoned me. All these things were on these complaints, around the Penal Code. And she said it was not that I was not correct, which means I was correct. She said, well, you can appeal my decision to the circuit court. Now, we have these courts here that say circuit court, but circuit can also mean county. Could be county court. About a week later, she sent me a letter, and the reason on all 3 of these things that she said that I didn't get my warrant was I had not given just cause. Not shown just cause or something like that. I said, oh, okay, later on, so I got to have a show cause. And so I did some videos here not too long ago about trying to get a show cause hearing for contempt of court. Because this is how the rule is written in Michigan, so listen real close, right? If an attorney puts in a document into a court case that is an error or an omission or fraud or whatever, right? Whatever the situation is, and you can tell by looking at it, it's considered indirect contempt of court. Indirect contempt of court, which means it was fraud not done before the court. But I'm standing in the courtroom right now, am I not? I'm in a courtroom. It's in a court case. I'm sitting in the frickin' court seat, what I think is the court, and yet by the statute for contempt of court show cause hearings in Michigan, I wrote a whole book on it, as a matter of fact. Good video, if I remember right. It says in there that this is considered indirect contempt of court. So that isn't the court that needs to know what the attorney just did. It's not the one you're in. All right, the one you want to go to is this dude, the county executive, who can administer the law, because he's over all these courts, which are really parts of the state court, and those attorneys in those courts are licensed by the bar to operate in these state courts. And any attorney is considered an officer of the court and always in court. So if you have a court case going on right now, there's any number of things we have talked about in the past that are correct as far as what the paperwork shows, right? That there's errors and omissions, such as there's no judicial seal, right? No judge has seen this. It's never gone to a judge. It's only gone to a clerk. Never went to the judge. Find a judicial seal on your paperwork. There's no sworn complaint by the plaintiff. The plaintiff on the document is a fictitious entity, as in just letters on paper, because you can't find a certificate of good standing for that name that is the plaintiff. The defendant is a fictitious entity. It's your business, right? If you look at your docket sheet, or you look at the way your name is going to be on a court case, it's going to be Rytlewski, Robert Allen. You're going to have your true real name, right? When they go into court, they're going to call Robert Allen Rytlewski. They're going to say, state your name. Robert Allen Rytlewski is what they want to hear, right? But at the end of the day, it's actually Rytlewski, Robert Allen, who has a court date. So Rytlewski, Robert Allen was never properly notified of a court. Forgetting all that. I don't want to even be in that court. I want to take that summons, which is incorrect, and the complaint attached to it, which is incorrect, and bring it to the county executive's attention that there's errors and omissions in this court case. And if they're not fixed, you consider it to be a false accusation. And you want to show cause hearing why the plaintiff's attorney should not be held in contempt of court. Because he's going to be listed as the attorney of record. And he's supposed to know better. He's the one who brought contempt of court to the court. The attorney did. And the easiest thing to do is point it out to the county executive before you go to court. Now, how you're going to write the complaint and so forth, I don't know yet. Right? I don't know how to do that yet. These are just thoughts that are coming together in my head as I'm understanding it for myself. Okay. They took the powers of an ordinary, and they split them up. And the powers go to the office, but the office powers have been split in three. You got a legislative arm over here, you got an executive, and then you got the judicial down here. United States county is politically and geographically a subdivision of the state. It's just a subdivision of the state. The exceptions are Louisiana, Alaska, which have functionally equivalent subdivisions called, respectively, parishes and organized boroughs. In other words, it may not be called a county. It may be called something else, but whatever it is, how does an answer to the state? Who's the chief administrator within whatever it is you're in that answers to the state government? To the chief executive officer. There's numerous consolidated city counties. That's another one. There's county equivalents. All this you can find in, this is just in Wikipedia under county, the United States. Alaska's got 19 boroughs. Counties still have significant government functions in all states except Rhode Island and Connecticut. The Commonwealth of Massachusetts has removed most county functions from 8 of its 14 counties. All right, so I don't even know if it's going to be called a county. It's just what's the subdivision of the state that you're in, and whoever the chief administrator is for that answers to the chief executive of the state. And we want it to be in the executive branch because we want them to execute the law. Earliest forms of local government. And again, when independence came, the framers of the Constitution did not provide for local government. Rather, they left the matter to the states. Subsequently, early state constitutions generally conceptualized county government as an arm of the state. It's the administrative arm, which makes it the executive arm. The president is the CEO, right? And it's his administration. A county, which is an administrative division of the state. It's the administrative arm. County equivalents, you got Alaska, independent cities, Baltimore, Maryland, Carson City, Nevada, St. Louis, Missouri, and all 39 cities in Virginia, where any municipality incorporated into a city in contrast to a town. So in Virginia, it's a city, not a town. You got 39 cities. That's a county equivalent. Washington, D.C. is a county equivalent. The site of the county's administration, again, so the state's administration, the state's executive arm, and often the county courthouse is called the county seat. Parish seat, borough seat. New England counties use the term shire town for the county seat. As you can see, it isn't going to be the same everywhere. Oh, let's see U.S. county name and who cares? Just different names. Powers of counties arise from state law and vary widely. You see, they keep using lowercase state. That's the interesting thing. When you go read like the Michigan compiled law for the state of Michigan, all the really good stuff for us is always in lowercase. You know, everything is lowercase, 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 right? And so the counties have the power to enforce these laws, but it's the chief executive who is the law enforcement of the county. He needs to enforce the law. And then the judge in the court case will judge by the law. And as you'll see in some of these other printouts, right? One of the things about this whole thing is that, like an attorney, he's guilty of an ecclesiastic crime. He committed a sin. And so we're going to the bishop. And we have the right to do that because he's agreed to have a court case that is being done under notary seal. And a notary is an ecclesiastic office. It just isn't going to the Catholic Church, right? Maybe not even going to the Episcopal Church. Maybe it's going to the correct office in the county as the executive, the executor of state laws. In many states, the board in charge of a county holds power that transcends all three traditional branches of government: legislative to enact ordinances, executive to oversee the executive operations, and quasi-judicial with regard to certain limited matters such as hearing appeals, yada yada yada. Alright, so the board in charge of the county. Okay. So they don't have true judicial power. That would be over in the judicial branch. But the thing is, who oversees the executive operations of the county? Who is that dude? The day-to-day operation of the county government are sometimes overseen by elected county executive. Oh, he is. Or by a chief administrative officer or county administrator who reports to the board, the mayor, or both. He may report to him, but it doesn't mean he answers to him. In many states, several important officials are elected separately from the Board of Commissioners or supervisors and cannot be fired by the board. Well, that's like a county executive. He's independent of the board, has nothing to do with the board. The board is writing the law. The judges are judging by the law, and his job is to enforce the law. County surrogate. There we go. Who's the county surrogate? Well, down in Georgia, they call this office the local ordinary. And it's also been the probate judge. So that's what a surrogate is. It has to do with probate, if I'm not mistaken. Power of county governments varies widely from state to state. However, some counties may have multiple seats or no seat. Go figure. In New England, counties function at most as judicial court districts and sheriff's departments. Now, this sheriff department here, right, it isn't 10-star sheriff. We're talking about the England sheriff, guy who may be elected once per year. If you have a board of like 5 or 6 people and they're always rotating the president every year, right, that's what we're talking about there. But it's just who has the chief administrative functions within the county is the guy that has the executive power of an ordinary. And he answers to the chief executive. In some New England states, such as Connecticut, parts of Massachusetts, Rhode Island, counties are now only geographic designations, and they do not have any government powers, right? So don't worry about it. Go find out who it is. It's just who's ever representing the state at a local level. Limited law enforcement duties. Yeah. And. Okay. In virtually all U.S. states, the state courts and local law enforcements are organized and implemented along county boundaries. Local law enforcements. But nearly all the substantive procedural law adjudicated in the state trial courts originates from state legislature and state appeals courts, appellate courts. Nearly all substantive and procedural law, we don't ever seem to have any of that. Unless somebody actually hurt somebody, murdered somebody, that's a different story. But most of the shit we're going into is all color of law anyways. Alright, so let's go to okay, ordinary. Again, an ordinary is an ecclesiastic name which denotes any person possessing or exercising ordinary jurisdiction Jurisdiction connected permanently or at least in a stable way with an office. Exercising the power of the office. Ex officio, he has these powers. Whether this connexation arises from divine law, as in the case of popes and bishops, or from positive church law, as the case mentioned below. Ordinary jurisdiction is contrasted with delegated jurisdiction, a temporary communication of power made by a superior to an inferior. Thus we speak of a delegated judge and an ordinary judge. Okay, so the judges that sit down in those courts are delegated to be a judge. They don't have it ordinarily by their office. I guess I could. Yes, I could. Ordinary jurisdiction is but still they don't have the one they don't have is the one to execute. Right, so the offices, so in the judicial branch, those judges' office has the power to judge by the law. But the ordinary one is the one that has the power to execute the law. That's where we need to take our complaint to. A person may be an ordinary with his own sphere and at the same time have a delegated powers for certain acts or the exercise of special authority. The jurisdiction which constitutes an ordinary is real and full jurisdiction in the external form. And external means out here in the world, comprising the power of legislation, adjudicating, and governing. Governing means to rule, means to execute. Jurisdiction in the internal form, being partial and exercised only in private matters, does not constitute an ordinary. Parish priests, therefore, are not ordinaries, though they have jurisdiction in the internal form. For they have not jurisdiction in the external form, not out here in the world, only in the church. Being incapable of legislating and acting as judges, their administration is the exercise of paternal authority rather than of jurisdiction properly so called. Right? So the local priest is not an ordinary. Is real and full jurisdiction in the external forum. Legislating, judging, governing. Governing is execution of the law. There are various classes of ordinaries. First, they are divided into these having territorial jurisdictions and those that have not. As a rule, ordinary jurisdiction is territorial. Boom, county. As well as personal. Boom, guy in an office. As in the case of a pope and a bishop. But ordinary jurisdiction may be restricted to certain persons exempt from the local authority. Okay? So who would it be at the federal level? All right, because I was talking to Jeff in Washington a little bit earlier, and he asked me, well, who would it be on the federal level? Well, who works for the executive branch at the federal level? Because the Department of Justice, I think, falls under the judicial branch. Does a U.S. Marshal, is he the executive branch? All right, he may be the one you take your complaint to. If it's a federal issue, so who's again, it's just, who answers to the chief administrator or the CEO to the president on a more local level, where in Michigan we have an eastern district and a western district. All right, so we're looking for the people that work for the executive office. Such, for instances, in this jurisdiction of regular prelates, abbots, generals, and provincials, they are not, like others, called local ordinaries. Okay? The jurisdiction of local ordinaries arises from divine or ecclesiastic law, an ecclesiastic constitution. Right? Them officers got their jurisdiction for the local ordinaries from the Constitution for the state of Michigan, which is ecclesiastic law. The Pope is the ordinary for the entire church and all the faithful. He has ordinary and immediate jurisdiction over all. He's going to start enforcing that. That letter he wrote a couple weeks ago is pretty powerful stuff. And I found a PDF that has some of those laws that he put in, and I'm going to do it as part of this video, but it may be like the second It's going to be the second hour, I'm sure, before I get to it. But interesting stuff. Bishops are the pastors and ordinary judges in their diocese appointed to govern their churches by the Holy Ghost. Certain bishops have, by ecclesiastical law, immediate ordinary power over other bishops and dioceses. These are the metropolitans, primates, and patriarchs. In the lower rank, there are other classes of ordinary prelates who exercise jurisdiction in the external form over a given territory, which is not a diocese. Well, the county executive, right? He could be a prelate in an ecclesiastic sense, either in his own name, as in the case of prelates or abbots, or in the name of the Pope. Well, I don't think he's doing it in the name of the Pope, so he's going to be doing it in his own name. Local ordinaries, being unable to personally to perform all acts of their jurisdiction, may and even ought to communicate it permanently to certain persons without, however, divesting themselves of their authority. So I think all the powers come from his office. He can perform he can enact a law, he can judge the law, and he can execute the law. And it's been delegated, but he still has all those powers. It's in the chief executive. If the duties of these persons are specified and determined by law, they are also ordinaries, but in a restricted and inferior sense. Okay, so again, I think his duties have been determined by law, whoever the chief administrating officer is of the county. This is vicarial jurisdiction delegated as to its source, so it was delegated to him by the chief executive officer, being let's say it's the governor of the state, but ordinary as to its exercise. So now he can exercise all three of them. He got all three of the powers delegated to him by the governor. As it turns out, the governor we could be talking about is at the appeals court, right? Because the other governor sitting up there, that's in the fiction. We're talking about in the county, in the de jure county. And when Michigan got started, they had a territorial governor and 3 judges show up one day, the day before the Detroit fire, or the night before was the Great Detroit Fire, and the new government shows up the next day for the territory. We're here to help. We can rewrite those deeds for you. Don't worry about it. And it's just the beginning of what we're in today. But so you had a guy who said he was the governor, and then 3 guys who said they were judges, and the 3 guys went into 3 different parts of the state, and they sat there as the circuit court judge, and they rode the circuit to all the different courthouses. A couple times a year they got together to form the Supreme Court. But they also were part of the legislature, as was the governor, and then the governor was also the governor, the executive. So none of them had all 3 powers, but each group, the governor had 2 powers basically, and the judges shared in 2 powers. And I just think it's the Michigan Court of Appeals, because they're the ones who have the seal on their wall of the Great Seal of Michigan. The Supreme Court doesn't have that. They have a different one. Be that as it may, that's a little bit off topic, but anyways, we're just right now trying to deal with the guys in the county. In this sense, vicar generals are diocesan officials, and diocesan officials are ordinaries, right? So one of the things that this guy, it's not the right page. It talked about county officials. It didn't say officers, it said officials. Right, so these persons possess and exercise exterior jurisdiction alone certain restrictions and by virtue of their office. So there are some people who just had the power by virtue of their office. right? So they don't call themselves an ordinary. It's just the power that comes by virtue of their office. In practice, the determination of persons included under the term ordinary is of importance in case of induits and the execution of rescripts issued from Rome. The execution of rescripts issued from Rome. See, we're trying to get because a rescript would be like your commission or your decree, final decree. The determination of persons included under the term ordinary is of importance in cases of induits and execution of decrees issued from Rome. We're trying to get him to recognize us as a Christian. So I was talking to Jeff earlier, and what he's thinking of doing is he's been to the county board meeting numerous times. In fact, he said he tried to put a fee schedule in once into the county at a county board meeting, and he got done saying this is what it was, and he started to head to the clerk, and these people hardly ever pipe up. They usually sit there silent, and they said, no, give it to the county administrator. Well, Jeff thought they were blowing smoke up his ass, because that's what we would think, and he tried to give it to the county clerk, and she wouldn't take it. But they had said give it to the administrator, right? They could have been telling the truth, right? It would be one of those things. They spoke. They actually told the truth. They opened their mouth and told the truth. So we were thinking more about this, and he's thinking of going and trying that again. I said, well, take in your baptismal certificate too, Jeff, and tell them that you're a Christian and you're not in the society of the Jew, right? If somebody wants to take you to court, it has to be an ecclesiastic court, right? You're in the jurisdiction of the Holy See. Because in that jurisdiction, everybody has to take an oath. They want to bring a claim against you. So he probably will. He's going to go down there and see what he can do to get it into the county, into the state, for them to recognize you as a baptized Christian. Alive, whatever it is. And I don't know if that has anything to do with getting our rescript from Rome yet. Our decree. But I tried to petition the Pope directly through the Pontifical Council. Still waiting to see how that goes, right? It's in the mail. But Bobby in Arizona, he went to the diocese and he took in the petition that I had done for the Pope, changed it to him, and was asking them how to get it to the Pope. And then they said, well, let's find out. And so they put it in an envelope and said I had to go to the Chancery Division. And he had already talked to Chancery about this, and he hadn't heard from them. That's why he was down there. But long story short, they came back and said, the Chancery saying that this office doesn't exist, and that they won't forward it to the Pope. Well, how can they not forward your petition to the Pope? Right? It's every baptized Christian's right to petition the Pope. He doesn't have to answer it. Well, I guess he does, but he doesn't have to fulfill it. But they won't even send it to the Pope, and they won't give it to the bishop. Now, again, if this is the judicial arm of the church, right, they don't have any executive power anyway, so it's really not the right place to take it. You would think it would be, but if their only power is as judicial, they can't execute it. And so now Bobby's going to send it directly to the Archdiocese in Santa Fe and say, hey, this has to go to the Archbishop, right, because I can't get any help from the local Phoenix diocese. Because there could be Masons, false Jews, the Khazarian Jews, the false Jews, sitting inside of churches. That's why everything's so fucked up. And not just the Catholic Church, the Roman Catholic Church, every church. They're all over the place. And that's why only we's are the ones that are going to be able to fix it, because when we get our commission, we get to judge in the name of the Lord. Or we come in the name of the Lord, right? Not really coming to judge, just coming to say you can't do that. If you do that, you may go to jail. And if they continue, you take your complaint to the ordinary and they go to jail. You just became a prophet. Okay, so since 1898, most rescripts, which are the decrees, instead of being addressed to the bishop, are addressed to the ordinary. So if you get a decree addressed to you, it just made you the ordinary. To declare, the term ordinary comprises bishops, apostolic vicars, prelates, or prefects of separate territorial jurisdiction, lawful administrators, just all different things that could be an ordinary. Thus the powers are handed on without intermission or renewal from one ordinary to his successor. Whoever holds the office gets the power. Ecclesiastic jurisdiction, the right to guide and rule the church of God. And what's a church? Well, it was the New Testament writers denote society founded by our Lord Jesus Christ. So in one form, it's a society of God. That's the society you want to be in. That society has its own laws. It is now agreed to derive from the Greek, the Lord's house. So it could also mean the Lord's house of God. Well, that would be your body, I'm thinking. So the right to rule and guide the Church of God, the Lord's house, us. General concept, classification, and jurisdiction. The church, as a society, founded by Christ for the salvation of men's needs, like every society, a regulating power, the authority of the church. That's what it needs. The power of Christ is bestowed upon it directly before his ascension. He gave the authority. He gave to the apostles collectively the commission, and with the authority to proclaim his doctrine to all nations, to baptize them, and to teach them to observe all things he had commanded. Now you understand that even as a member of the laity right now, you have the power to baptize somebody. You can baptize them as long as you use the right form and substance, and it's a valid baptism. So you're the apostle they're talking about. That's what a lay apostolate is. Not an apostate. An apostate's bad. An apostolate. It's an apostle. You're a lay apostle. And in some degree, it rejects the doctrine that Christ did not desire to found a permanent, unchangeable church endowed with authority. Back in the early 1900s, in the Enlightened time, people wanted to say that Christ didn't have any plans of having a permanent, unchangeable church endowed with his authority. That's what some people's doctrine was. Well, bullshit. Sure he did. He gave it to the apostles. And it was handed down from them. It is customary to speak of a threefold office of the church: the office of teaching, the prophetic, the priestly office, and the pastoral, the governing. Also, therefore, threefold authority of the church. That is, teaching, ministerial, and ruling. Since, however, the teaching of the church is authoritative, the teaching authority is traditionally included in the ruling authority. Regularly, therefore, only the ministerial authority and ruling authority are to be distinguished. Okay. The teaching authority is traditionally included in the ruling authority. So now the question is, who has the authority to rule as separated from who has the authority to be a minister? Well, by ministerial authority, which is conferred by an act of consecration. It is meant the inward, and because indelible character, permanently capacity to perform acts of divine grace is transmitted. Okay, so by an act of consecration. Now, were we consecrated when we were confirmed? Is that a consecration, or is a consecration when you go into holy orders? Are they saying the ministers are the priest and so forth, but they're not the ruling authority? By ruling authority, which is conferred by the church, is understood the authority to guide and rule the church of God, which is the society of God, or the Lord's house of God, other Christians. Jurisdiction, insofar as it covers the relations of man to God, is called jurisdiction of the internal form. So when I'm reading this here, right, therefore only ministerial authority and ruling authority are distinguished. The ruling authority has to be the princes of the church. It has to be the cardinals, because they would be the princes of the church. But the only reason they're doing that is because we haven't stepped forward as the lay apostolates to rule the church with the same authority as a cardinal, except we'll have our own name, and it's a Christofieldus or something like that. That's the office we want to get. Jurisdiction, as far as it covers relations of man and God, is called jurisdiction. Okay. Jurisdiction, insofar as it regulates external ecclesiastical relations, is called jurisdiction of the external forum. That's where we are. This jurisdiction, the actual power of ruling is legislative, judicial, or coactive. Okay, the actual power of ruling is legislative, judicial, or coactive. See, we should be judging by God's law, and that's what we're going to do, and we're going to take it to the ordinary executive, the ordinary, to point out the transgression so that he can administer the law. Ordinary jurisdiction, that which is permanently bound by divine or human law with a permanent ecclesiastic office. Its possessor is called an ordinary judge. We will be an ordinary judge when we get our rescript from the Pope, because they don't come in the name of the bishop now, they just come in the name of the ordinary. Prelates with quasi-episcopal jurisdiction. Who are they talking about there? I think they're talking about state officers. If, however, jurisdiction is permanently connected with an office, but the office itself is said to be quasi-ordinary. Okay, so there's jurisdiction permanently connected with an office, but the office itself is quasi-ordinary. Okay, what does that mean? In this transient form jurisdiction called delegated or extraordinary, and this all happened because this development began when the popes, especially since Alexander, we're talking 1100s, found themselves obliged by the enormous mass of legal business which came to them from all sides as the judicious ordinary omnium, number one ordinary, I guess, number one judicial ordinary, to hand over with proper instruction a large number of cases to third parties for decisions, especially in matters of conscientious jurisdiction. Delegated jurisdiction rests either on special authorization of the holders of ordinary jurisdiction or on a general law. So that's how the delegated jurisdictions are established. In the Council of Trent, they had two as the delegate of the Holy See, and then even as the delegate of the Holy See. First case, bishops do not possess ordinary as a delegate of the Holy See, right? They don't have ordinary jurisdiction. Their power was delegated by the Holy See. The first class cases, bishops do not possess, so bishops do not possess ordinary jurisdiction as the delegate of the Holy See. The meaning of the second expression, even as the delegate of the Holy See, is disputed, but generally taken purely cumulative. If the delegation applies to one or several designated cases only, it's a special delegation. If, however, it applies to the entire class subject, then it is a general delegation of delegation for the university of causes. So if, however, it applies to the entire class of subjects, it is then general delegation or delegation from the universality of causes. Okay. For acts of jurisdiction, he must be an ecclesiastic. Though the Pope could also delegate a layman. Go figure. So, doesn't have to be an ecclesiastic. Could be a layman. Those placed under the jurisdiction of the delegator must submit to the delegation. Those placed under the jurisdiction of the delegator must submit to the delegation. So who's the delegator? Is that the governor? The delegate is to follow exactly his instructions. He is, however, empowered to do all that is necessary to execute them. That's wonderful. The delegate is to follow exactly his instructions. And this dude's instructions was to enforce the state laws, the county executive. And he is empowered to do all that is necessary to execute them. So he can pick up the phone and make shit happen. Since delegation consists of new court appeal, can be taken from the delegate to the delegator, and in case of a subdelegation to the original delegator. Okay, so new court appeal, right? You're going to appeal what's happening in the court you're in now. You're going to go to a new court to appeal. And you're going to go from the guy that was delegated to the delegator. And the delegated judicial power of the judge came from the office of the county executive, the ordinary. Delegated jurisdiction expires on the death of the delegate, in case the commission were not issued in view of permanence of his office. Okay? In case the commission were not issued in view of permanence of his office. That would be like a judge appointed for life. In the case the delegated has not acted, delegated jurisdiction expires on the death of the delegate. In case the delegate has not acted, that's what we're not doing, right? We have delegated power too. Ours came from the Lord. We haven't done our thing. On declaration of the delegate that he has no power, somehow they must get to sign a piece of paper saying we have no power, because we were commissioned by God, right? In case the commissions were not issued in view of a permanence of his office. Well, yeah, we were commissioned by God to speak in his name. But, right, it's going to expire on the death of the delegate in case the commissions were not issued in view of permanence of office, or on the loss of office or death of the delegator in case the delegate had not acted. Right, that's the main thing. We just haven't acted. Development of jurisdiction in the strictest sense. The church has the right, as a perfect and independent society, provided with all means of attaining its ends, to decide according to its laws disputes arising concerning its eternal affairs, especially as to the ecclesiastic rights of its members. The ecclesiastic rights of us, right? We want to go to the church where they have to take an oath. And also carry out its decisions, if necessary, by suitable means of compulsion, contentious, or civil jurisdiction. It has, therefore, the right to admonish or warn its members, ecclesiastic or lay, who have not conformed to its laws, and also, if needful, to punish them by physical means, that is, coercive jurisdiction. That's why we're going to the ordinary. Because it has the right to admonish or warn its members, ecclesiastic or lay, who have not conformed to its laws. And the laws we're talking about now are the ones that, when they say we're not following the procedures and we're trying to follow the state law, those are the laws they're talking about. Just can't take it to the judge. It has to go to the executive. The church has first the power to judge sin. Well, what's a sin? A false accusation, fraud, covet my property, lie, cheat, steal. This is done in the internal form, but a sin can be the same time externally a misdemeanor or crime when threatened with external, ecclesiastic, or civil punishment. We're trying to point out crimes. We're going to point out penal code violations, whether we call them that or not. The church also judges ecclesiastic crimes in the external form by infliction of penalties, except when the wrongdoing has remained secret. And this is the thing about the indirect contempt of court. It's been kept secret from the ecclesiastic court in the internal forum, not the external forum we're in. We're going into the external forum. We want to go into the internal forum because it's a church matter. It's a matter of faith and sin. And the church has first power to judge sin. This is where it gets good. And I'm going to stop here because this is going to stop in a few minutes. So let me stop here and I'm going to start another one. We're going to talk about the voluntary subjection that these attorneys put themselves into. And we'll continue on from there. Okay, see ya.